this. We appreciate it.
Yes, and thank you all for working with me on this too, so I appreciate it. Thank you.
Mr. Chair.
Delegate Bell.
The patron of Senate Bill 476, Senator Reeves, has said that he would like to continue working on this throughout the year. We had tried not to have a lot of 5 years, but permission from leadership on this was another mistake.
So there's a motion is to carry over under Rule 22. Senate Bill 476. Is there a second?
Second.
Okay. Any further discussion? It will be by voice vote. All those in favor say aye. Aye. Those opposed? All right. Senate Bill 476 is recommended to the full committee to carry over for the year. Delegate Bell.
Chair, we have 2 patrons left. Senator Stanley, is here. Sent me a text saying take get a coffee while we did these. Stanley has 4, Deeds has 1.
Senator Deeds, Senate Bill 669.
Thank you, Mr. Chair. I think there's a technical amendment Mr. Cotter pointed out to me, and that is a draft engineer. I'm embarrassed that we didn't catch it in the Senate, but it looks to me like it's necessary to make the bill do what it's intended to do.
Mr. Cotter.
Mr. Chairman, on line 92 at the beginning of the line, you would strike the word involuntarily and insert the word voluntarily.
I'm sure that doesn't matter.
Just 2 letters. So I move.
Delegate Bell moves that amendment. All those in favor say aye.
Aye.
Those opposed? That is adopted.
So under existing law, if you're subject to a TDO order and you're 18 or over, you're not ineligible to possess or own or purchase a firearm. If you're under 18, you can't purchase a firearm. But if you're 14 to 17 and subject to a TDO order, you're not necessarily prohibited from having a firearm when you turn 18. Now, I realize that, I think this bill is the law as we all thought the law existed. But I didn't realize there was a problem until this past year. This grieving father from Stafford County called me and said that his son had attempted twice to take his life, had been committed, been subject to a TDO order, and he was looking forward. He was talking about what happened when he turned 18. He would purchase a gun and finish his business, and that's what happened. And so we're trying to put the law in a position where we always thought the law was with 14, 15, 16, and 17-year-olds. That's all the bill does.
Mr. Chair.
Delegate Bell.
So I have a series of questions for staff related to Senator Deeds probably knows this also. Thank you. So, up into a certain age, the parent can just do it. That is how old?
Up to 13, under 14 years of age.
Okay. And then 14 through 17 is what we're talking about, which would be the minor, but it's not the only way that they get involuntary treatment is through this process.
That's right.
Okay. And is it the same process we think of as adults for ECO, sometimes paperless, TDO for whatever
I
it is,
think it
96
is.
hours, and then a commitment hearing thereafter?
I think it is, yes, but with staff may.
Mr. Chairman, it's generally the same process as the proposed.
Okay. And what happens is, at some point, it goes on to the background exchange, and it comes up in the instant background check. Is that right?
Under current law, there's no mechanism for juvenile.
No, I'm still doing it. I'm just trying to do the parallels. For adults,
Yes.
there comes a step, and then it goes. What step is that?
37.2.819, Mr. Chairman, which is the analog language of what's included in the bill under lines 48 to 80, is the statute that requires the magistrate court, whoever's doing the commitment, to send it to the CCRA so it be put in the permanent record.
Is there any issue about putting a minor's information into the background check?
Mr. Chairman, we do have a delinquency findings now, so the VSIN is very tightly controlled, as the committee is very well aware, and so it would be, and there's in the bill, in the language, there is that no medical records shall be put into it, and it's only through a form that is pursuant to something that the Virginia State Police and the CCRA would come up with, so it's very limited.
Okay. And then that's the involuntary side, and the other one was that, I think of it as the elbow rule, but in 07 and 8, we discovered that you could, right before being committed, agree to go. In other words, you get TDO, you're brought in, and right before they say, I'm about to do it, you go, okay, I'll do it myself, and that group wasn't being identified. We fixed that for the adults, this covers that too.
That's included in this as well, and it requires the person doing the commitment to inform them that their rights to
Mr.
possess
Chair.
a firearm is going to be curtailed by this.
That's what the technical amendment fixed.
Okay.
Down on lines 90 through 93, 94.
It looks like it's line, I'm just reading it alongside the 819. It looks like, let's say we worded it particularly poetically, but it looks like it's the same language as that. Okay. Yeah, for the adults. Mr. Chair, just because of the typo, might we, I'll just 5 minutes to read it, or you can talk while I read it. Thank you.
We're all just gonna sit up here and read for a minute, so don't be alarmed if we're not talking. Okay, are there any questions for the patron? Anybody in the audience wishing to testify in favor of this bill, please come forward. Anybody in opposition? Bill, you go.
Okay, we have. Senator, I'm just reading them side by side. After, when somebody says there's a technical error, it makes you go, oh gosh, I just want to triple check one more time. All right, so, Mr. Chair, I'm going to move to report.
Senator, I think there was some discussion about making sure this bill doesn't get any bigger or broader, is that?
And you've got my assurance that won't happen. If you typically, if my experience in the past anyway, when a governor of my party wants to amend now the governors of the other party sometimes have amended them anyway, but when a governor of my party wants to amend a bill, generally, if it's my bill, he's gonna check with me, and my instructions to that governor will be this bill is as broad as it's gonna be.
I appreciate that, and it's a bill that makes sense, and I can't believe that
I know,
that
you know,
lapse existed in the law anyway.
I didn't hand out this man's story because it conveys pretty well anyway. I think it's heartbreaking what his family went through.
Thank you, Senator. All right, so the motion is to report. Any further discussion? Everybody, please cast your vote. All right. Close the roll. Your bill is recommended to report. Thank you, Senator. Senator Stanley, you have the rest of the agenda.
Well, you can just take it up and walk.
Unless you, we can do that. But,
Mr. Chair,
uh,
I had a chance to speak to Chairman Stanley. There's a couple that are similar to things we've done before, or that we can, I think, move more quickly.
okay, let's go.
So the Senate Bill 35, we had a similar version, but not rather than conform it. This is the one we've been holding on the floor until this very moment, because they got to it after we did. And it might be that if we take his words, we would simply accept the Senate amendment and move forward.
I don't know what you just said.
All right.
But-
We sent our House version over to Senate.
Okay.
Everybody had more time to work on the House version than the
This
same
year?
group of, yes, sir. The
Okay.
same group of people in this room came up to a set of words that are now in Senator Stanley's bill.
Okay.
If we accept
Oh,
his
all right,
words,
sorry, I was thinking of.
then rather than go to conference and start getting down, we can just accept the Senate version on the floor and we'll avoid conference for everybody. So I'm suggesting that we not simply do what we sometimes do, which is conform everything.
You don't want to conform.
I don't. Long lead up to be a Saturday night, I'd like the senator to make a presentation. If we like this version better than Collins is, that'll be the way to go for it.
Happens a lot.
Please.
There's a substitute amendment, the nature of substitute.
Senator,
We know the concept, but I guess the issue would be, how is this different from what we already did on our side, or even?
Mr. Chairman, members of the committee, I do believe that my good friend Delegate Collins is probably more well-versed on this than Cotter, since it was just brought to my attention, but from what they told me in the short, I certainly agree with the amendment in the nature of a substitute. So if you would permit, my good friend and colleague Delegate Collins from the BCJC Commission, he can probably do it better than I can. Or Cotter would really be better,
Okay, Mr. Cotter.
because then.
So close to my moment in the sun.
Go.
Cotter's more of an intellectual here. I think that's what.
Mr. Chairman, Delegate Collins' bill, as passed out of the House, included conspiracies and violations of principle in second degree or accessories before the fact. That language, when they conformed Delegate Collins' bill to Senator Stanley's bill in the House, dropped out. However, an amendment that was added in the Senate dealing with substantially similar offenses committed in other jurisdictions was included. So what the substitute in front of you does is actually brings all of those pieces together, and now it includes both the amendment adopted in the Senate as well as the language that was originally in Delegate Collins' bill that was voted out of the House.
Delegate Collins,
Yes.
would you like to add it?
No.
All right.
Mr. Chair,
No, you bet.
it sometimes happens, people give us more credit than we deserve. Could the senator or the delegate or the intellectual, just starting from scratch, which is what we have today, if this passes as it's written here, just walk us through what it does.
I yield to the intellectual.
Mr. Chairman, what this bill does and what Delegate Collins' bill 188, House Bill 188 did, is it allows, in the case of a person who has been convicted of crime who renders substantial assistance to Commonwealth's attorneys in prosecuting of other offenses, to have a sentence reduction. And so the offenses that were covered in Delegate Collins' bill and in Senator Stanley's bill as introduced was acts of violence listed 19.2-297.1 as well as drug offenses. Delegate Collins' bill also includes conspiracies to commit those offenses as well as principles in the second degree and accessories before the fact of those offenses. In the Senate, an amendment was added to the Senate bill to also include and substantially similar offenses in any other jurisdiction. And so the product that is now before you brings both of those concepts together and puts them into the one bill.
And does it still require the Commonwealth of the jurisdiction to say, I think this is the person that prosecuted, so to speak?
Mr. Chairman, Delegate Bell, it's the Commonwealth's motion.
Okay.
It's their toolbox.
But I mean, somebody does something in Albemarle County, sure, that's the most important thing in the bill for me. In Collins' district, they want to use my guy to help them. I'm the one that gets to say that we reduce the sentence at Albemarle County. He doesn't get to sell my conviction cheap or something.
That's correct, because jurisdiction would rest with the Commonwealth's attorney in the area in which the conviction occurred.
But we had to have the out of state.
Right.
Or someone being held out of state.
Mr. Chairman, the only differences between the two versions of the bill deals with the offenses listed, not the mechanics of how this process works.
And this has added the additional offenses.
Yes.
Okay.
Okay. Any other questions for the patron? Anybody in the audience wishing to testify in favor of the bill, please come forward.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of College Attorneys. We do support the bill.
Anybody in opposition? Okay. There's a motion to report.
Second.
There's a second. Any further discussion? Please cast your vote. Whoop, sorry. Is there a motion to adopt the substitute as my clerk dutifully reminded me 5 minutes ago? Is there a motion on that?
Yeah.
Okay, the substitute is adopted. Motion is to report the substitute. Close the roll. All right. That bill is recommended to report.
Thank you, Mr. Chairman, members of the committee.
So we have one that I understand is going to also ask to go by for the year. Again, I haven't gotten the blessing of that one also. That's the Senate Bill 777.
Okay. That's the writ of actual innocence for the scientific.
Good hospitals.
Do you have an idea what you're going to do with that, or do we have to? Okay. It's a good idea, but it needs some work.
I'm not looking for it.
Okay.
I am.
That's fine.
I know it doesn't
I
matter.
understand. No, it is. After the year was voted.
Yes, indeed. No, I'm grateful.
So the motion is to carry over. Is there a second?
Second.
You made the motion. Is there a second?
I get two votes.
All right. All those in favor say aye.
Aye.
Those opposed, all right, that bill is recommended to carry over on Rule 22.
Mr. Chair, I purposely wanted to wrap up with 168 because we've all seen that many times before and it's probably in the front discussion. So I would suggest we do the other one first, Senate Bill 36.
Okay, Senate Bill 36.
Mr. Chairman, members of the committee, may it please, Senate Bill 36 is a weekend jail time bill that allows, with the concurrence of the Commonwealth, those persons who have been sentenced to a nonviolent felony in the Commonwealth of Virginia whose active portion of their sentence or remaining active portion of the sentence is 6 months or less, to be through the blessing of the Commonwealth at their discretion and the agreement, of course, at discretion of the judge, to permit that person to serve that time on weekends. The reason for this is especially in my area and other areas, and especially what I've seen in my practice, is a lot of times what we're seeing is very good people who have jobs committing felonious acts that revolve around nonviolent offenses such as drugs. Most of this is drugs. They're good people, they're addicted, but what we do in the system is often is that when we convict them of a felonious charge and we sentence them to an active portion of incarceration, most times, because their employer, unless their employer is very special or a family member or something, most times that person loses their job. And so when they get out after they've served their debt to society and paid that debt, usually they're unemployed. And usually their employer that probably valued them and wanted them to stay there has now moved on and found someone to fill their role. So then the chances of those persons convicted of these nonviolent offenses who served 6 months or less on a felony conviction then are not only without a job, they've got a felony conviction, which may prevent them, some employers may not be willing to give them a second chance or to give them that chance. What this bill does is allow these people who have committed these nonviolent offenses, these felonies, to serve weekend jail time, to keep their job, to keep working, to keep paying child support, to support their family, to keep their benefits, and keep them working, keep their skills sharp. Because ultimately what we want to do, Mr. Chairman, is make sure in these circumstances, not the other circumstances, violent crime, crimes against others, but in these circumstances where the court and the Commonwealth deem appropriate, is try to keep this person as being a taxpayer so that when they pay their debt to society, they go back into society, we keep them from committing other acts, and they're a taxpayer, not a tax burden. Because if they come out without a job, chances are higher, as statistics have shown, that they may commit other crimes in order to feed their family or survive. Or they may not be able to find that job that they had for so many years and was so loyal to their employer that they won't be able to get another one and they go in public assistance. So I lovingly call this the Delegate Klein and I get to talk every year bill, but I do believe that Delegate Klein, after much discussions with myself, is probably for the first time.
Wow, I'm gonna listen.
At least I'm willing to listen, Mr.
With
Chairman.
most defendants that you're talking about, that they are starting a job on Monday. Have you ever heard? Do set those. Anyway, go ahead.
Mr. Chairman, all my clients are always fully.
I'm starting a job on Monday.
But again, Mr. Chairman, even in that instance, then a prosecutor like Mr. Doucette and other prosecutors could weigh that, could see whether it's legitimate or not, or even, and if they object, then that doesn't occur. Sure. And even if they consented, we still have another barrier, which is the judge could make that
And you're right, we've all had clients that stand to lose a lot by becoming incarcerated. Yes, and Delhi Bell would certainly, that would be the time where he would have chimed in to say they shouldn't have done whatever they did to cause them to lose that job. But anyway, this has the Klein amendment in it from the previous year. Sorry. Is that the one that says the Commonwealth can object, and if they do object, it's no deal, right? So, okay. Any questions for the patron? Anybody in the audience wishing to testify in favor of this bill? Anybody in opposition to the bill? Please come forward. Mr. Jones.
Mr. Chairman, members of the committee, I'm John Jones, representing the sheriff. We're opposed to the bill. There are two issues. One is, and the sheriffs are really concerned about the management issues this is going to create in the jail. And I think, Senator Stanley said, these people are addicted. And what happens, you can't always search. We talked about that earlier in the session. It just brings a lot of contraband. And the weekends, more and more contraband gets into jail. That's a real management issue for the sheriffs. Once it gets in that jail, who knows what kind of deal they made, what happens to it. It's a big issue for the sheriffs, and they're opposed to it for that reason. But they're also opposed to it because it's going to create some crowding problems with the 90-day, even the 90-day clause. You're talking about 45 weekends. So if you have one inmate, then you've got almost a year of weekend time that he's going to be doing in that jail, and that's an issue. Some sheriffs are opposed to it because they just simply think if you get convicted of a felony, you ought to do your time.
Thank you, Mr. Jones. Okay. So the whole reason we put that, go ahead, sir.
I am Jeff Newton. I'm representing the Virginia Association of Regional Jails. I'm superintendent at the Riverside Regional Jail. We are in opposition of this bill for many of the same reasons that Mr. Jones represented to you. It's a management issue for us. Currently, as you understand, it's for misdemeanors only. At my facility, I manage 1,000 offenders a year that are sentenced to non-consecutive days. And what my data tells me is that anybody sentenced to 10 days or less got about a 75% success rate of completing that. You get farther out than that, we're dropping down to 50%. And so now we're gonna put nonviolent felonies, we're gonna increase the number of folks. It's gonna be a problem in managing that population and the volume of people coming in. Okay.
Thank you, sir. Mr. Chairman. Sir.
Sir,
Sir, could you come back?
you just happen to be the person standing in front of me. So where we are, what the judge said, the judge has an order that he gives down a dozen times a week. And it says if some version of the jail can manage it on weekends, I hereby say it's fine. It's not an order. And we do have times that the jail just says we can't, we've got too many weekend people, can't manage it.
We do that with work police all the time,
Okay.
if eligible.
Is it your understanding under this that if the judge orders it that way, that you can't make that determination?
That is correct.
Okay.
It's an order from the court.
Senator Stanley, is that your intention? I say that because where we are, okay, that's fine. Then their beef at least has a. Do you think, is it just that this will increase the volume? In other words, there are some misdemeanor, I'm thinking the second offense, assault, battery, or someone really got hurt would be, most people say is more serious than some of the felonies in terms of just how dangerous, how everything.
Well, I'd also like to remind the committee that we change, there's a potential for a change in felony theft level. So the vast majority of folks that come and serve weekend time are traffic offenses, misdemeanor drug offenses, and misdemeanor theft. And so now we're going to raise the misdemeanor theft level from $200 to $500, potentially that. So we're expecting to see the number of folks eligible for non-consecutive days under the current statute expand, and then exacerbating it further by adding nonviolent felonies. It's going to be a problem for judges to manage.
Mr. Chair, I'm not sure if this is a question for the speaker or if it is a question for staff. My understanding has been since at least 2002 that someone who is eligible or who is required to serve a mandatory minimum sentence is not eligible for a weekend sentence or on electronic monitoring or any other deferral. I think the site was Cuffy Smith v. Commonwealth.
Chairman, I'd say I can't opine one way or the other. Have not read the case itself, but didn't know that was issues.
I would say that I'm not aware of that being a rule application everywhere, because I'm not aware, of course, that they say you gotta serve every day, you don't get a good time. In other words, 10 days means 10 days, but we don't have to be consecutive.
And right now, Mr. Chairman, Delegate, I would say that, this comes off of a prior Attorney General's opinion that said any felony conviction had an active jail sentence could not, it was the Attorney General's opinion that could not be served on weekends. So any felonious conviction with an active jail sentence, mandatory minimum or otherwise, could not be that way.
Mr. Chairman.
Question for, well, the sheriff. Mr. Jones, this bill's been brought, how many years have you brought this bill? 4? Is this the first year the sheriff's opposed the bill? No? First year I recall.
Did y'all support it after the change involving?
They supported it.
Objecting?
We had a different committee for elections. We supported the 90-day thing, but there was still a lot of reluctance within our ranks. So this year, I can say that it's pretty solid against it.
I guess what I want to know is, in previous years, when we said that the Commonwealth could object, and that was an absolute bar to this sort of treatment, I thought that you all either were okay with it or stood down or something. Didn't oppose it any longer once that.
Yeah, but we're here this year. We're supposed to be this year.
As I have a judge that says the law is ever changing, so I guess the law is ever changing. All right, yes, ma'am, you waited patiently, I would appreciate your thoughts.
Mr. Chairman and members of the committee, my name is Blythe Bowman. I'm an associate professor in the L. Douglas Wilder School of Government and Public Affairs at ECU. And I've been doing a lot of independent research on weekend jail and how it works across the Commonwealth. And maybe I can clarify a few things because I have data from hundreds of jailers and citizens from across the state. And my findings are very much in line with what Mr. Jones and Colonel Newton have said today. As far as the nonviolent felon thing goes, the results are loud and clear. 68% of your jailers do not want it, and 58% of your citizens don't want it either. The problem is that these nonviolent felons are still felons. These are people who have committed offenses for which they could go to prison. And people just don't feel safe having them out in the community 5 out of 7 days of the week. Now, the jailers are also concerned about safety and security in their facilities because you've got weekenders coming in on the busiest day of the week. They're getting booked in and released over and over and over again, and that's just giving them multiple opportunities to try and introduce contraband into the facility. And that's a whole new level of risk and liability. As far as your substance abusers who are on weekends, if I may be blunt, they just drink or shoot up during the week. Which is pretty clever. They figured out how to time it so that there's nothing really rehabilitative about it. And most weekenders, as Colonel Newton said, tend to flunk out of weekend jail programming anyway. So it's not really much of a deterrent either.
Do you want to be on this committee?
Not if Bill Stanley represents.
Tom, do that. No, keep going.
Okay, I'm almost done, I promise. So in fact, I would actually go as far as saying that weekend jail really isn't much of a punishment at all, because essentially what you're doing is it's minimally intrusive by design. You're letting these people do time when it's convenient for them, and there really aren't any consequences. And I'll tell you very frankly, inmates love this stuff. I have a job starting on Monday. They sit and joke about how easy weekend jail is. They think it's funny. Back to the bill provisions, jailers also say absolutely not to using weekend jail for reasons other than gainful employment, mainly because we already have programs that you can do this with, like probation and house arrest and work release. And as far as the 90-day provision, the jailers say absolutely not. They say it should be the final 30 days of a sentence that could be done, because 90 days, as Mr. Jones pointed out, is just too many weekends, too many failures, too many risks, too much liability. So based on what I have found in my research, I would respectfully recommend that you not support any of the amendments in this bill. No to the nonviolent felons, no to the expanded court discretion, and no to the 90-day provision.
So can I just ask you about
Yes, sir.
your research
Yes, sir.
specifically, how, who you surveyed and
Sure.
how you did that? Yeah.
Sure, so in terms of the correctional staff, with the assistance of getting lists of contacts from the Virginia Sheriff's Association and the Regional Jail Association, we did, my GTA and I, did an online survey that went out to all the sheriffs in the state, whether they ran a jail or not, and it went out to all the regional jails as well. And in terms of the citizen feedback, that was a question that I put into VCU's 2016 public safety poll. We specifically asked them whether they would support that particular provision about including nonviolent felons, and they said absolutely not. So there were 1,000 citizens across the Commonwealth that were surveyed in the public safety poll.
Okay. All right. Well, thank you.
Thank you.
Appreciate it very much.
Mr. Chair, Bill, sort of process and institutional question. So, did any of this come up?
First, she really believes in redemption, doesn't she? Clearly, the facts show that.
Did this come up in the Senate?
Mr. Chairman, I'll give it now.
Let me just say this, which would be, we have a bicameral process here. This is an effort to adopt the House position from some time back. Kind of awful late game, everybody. Senator Stanley, I talked to him about bills all day, but here we are. Would there be any, yes,
They
Senator?
did not oppose your bill on the Senate side?
No, they did. He did voice his opposition.
Okay.
And looking through the other bills, I see where I had share support 2 years ago. Yeah, 2016.
Is there any, this is not our last meeting. We kind of did all yours, so you wouldn't have to bother with us.
I appreciate that, although I love being here with you.
Would there be any value to Wednesday and seeing if you want to sit with them and see if there's something you work out, or is it not?
Does it have to be John Jones? Listen, I'm willing to do anything. I think what we've turned this to the point where, one, it has the safety valve of Commonwealth's got to agree. Commonwealth, as you know, Mr. Chairman, members of the committee, are in tune with their sheriffs. They're usually in a building, either the same building or close by, and so are the judges as well. Ultimately, what we're trying to do when we talk about a people management problem, what we're talking about are case-by-case basis where the judge feels that this is appropriate because of a job, because of maybe even special needs children in the job and required in child support, whatever it might be. So we have to kind of trust at that level that that's going to occur, number one. But number two, I think, when we talk about people management, what's the management of us when we have to pick up the tab because they can't get a job? What's the people management, what's the cost for people management when without a job, without hope, because we took their job away, because we made them serve an active sentence for a nonviolent felony, that now they are back in the system and we have recidivism being a problem. So that's really what we're trying to craft.
I'm certainly sensitive to what you said, which is that in most places, I would think, all the sheriff has to do is call, or the regional jail administrator, call the Commonwealth attorney and say, look, they're giving us fits in here, and please put a stop to it. And on the one rare occasion where somebody does have a long time, good job, they're gonna lose it, and everybody thinks it's in society's best interest for this person to keep their job and have it when they get out of jail, that this is a tool, strikes me, which is how we arrived at this position to start with the Commonwealth being able to object, but I would certainly like everybody to try to work it out as best they can if possible. So,
Sure.
I'll give it a shot.
Why don't we put it off to Wednesday? Now, that is our last day. And I said, everybody, I'm feeling this, we've all voted for this before, so if y'all are thinking that this is not going anywhere, I would encourage you to work with the senator. Senator, I would say 90 days is a long time on felony time.
Yeah.
I think I started out at 6 months, and that's where I had it in my head again, so it's down to
Misdemeanor, when you cut it in half, of course, then this is 90 days, 85% of that would be whatever it comes to. It's a lot of weekends, and I know our
11
judge,
days off, so it'd be like 80 days.
I know my judge would never do it for the right reason, which would just be, Stanley, there's no chance, and God's green earth, you will successfully get there by Friday at 5 o'clock, clean, sober, ready to start for 20 weekends in a row. I know there's a magic number, but it's some number smaller than that would be the one where I think we can realistically hope someone, you're set up to fail.
And Mr. Chairman, I'd say to the delegate that I think this would be used as a tool in the toolbox, again, to use that euphemism in not large situations, but in those small appropriate situations in terms of numbers. But I'm happy to talk with John.
Bye for the day, we won't keep you on Wednesday, okay?
Well, that's fine.
We'll go bye for the day.
I'll be happy to stay here.
And Senator Stanley, you had Senate Bill 168,
168.
taking another stab at an ongoing.
I believe there's a amendment in the nature of a substitute.
Okay.
So,
Delegate Bell moves the adoption of the substitute. All those in favor say aye. Aye. Those opposed, substitute is adopted. Senator Stanley.
Mr. Chairman, members of the committee, Senate Bill 168 tries to tackle a problem I know we've looked at before. This comes to me from our Deputy Commonwealth Attorney in the city of Danville, Ms. Haskins, who worked on this issue with me, to try to address the problem that we've seen and we're all seeing a little more frequently than ever. I mean, when y'all and I went to high school, we didn't have smartphones in our hands, we didn't have technology, even the internet readily accessible as well, for most of us. And so what this tries to do is really in a narrowly focused way. And the amendment now changes the definition of what they're possessing to child pornography rather than a sexually explicit image. And what it is in those cases, and I've seen them, Mr. Chairman, I've had my Commonwealth attorney and myself being a defense lawyer in a situation where this happened, where a picture was transmitted to a boyfriend retransmitted, showed it all who was in possession. And what we had was, in the long run, 9 people, 9 young men and women, who were then in possession of or could be charged with and were charged with transmission of child pornography, a felony, an offense by which a conviction has significant and serious consequences. And yet here we stood with myself and the Commonwealth attorney, this was years ago, and other defense attorneys knowing that it really wasn't, that the law didn't fit what we saw as the crime. So it presented for that attorney, that Commonwealth attorney, an all or nothing proposition. It's either a felony and everything that goes with it, or it's nothing. And what this does is this creates a very narrow valley by which, if that occurs in that setting, and remember, it is in the high school setting that we're really trying, in the school setting that we're really trying to get at. And if it looks like this is something that is occurring, then they have the option the Commonwealth attorney has the option to charge under this what would be a new statute, which would allow that child, that young person who is in possession or transmits child pornography, as we know it to be, not as we know it to be in this setting, not as we see it from bad external manners in which it's transmitted in other ways. But when these pictures, these sexting pictures are transmitted, that the Commonwealth, using its own judgment, can determine for itself that this is something that would that might be right for the ability to charge as a class 1 misdemeanor with publishing and dissemination or possession, and then based on the number of images could be a class 2 misdemeanor, but then to have, if it's a first offense, it has never happened again, to give judges or give the Commonwealth the discretion to allow this to be handled under a first offender status, where the matter would be continued. They would perform 100 or 50 hours of community service, and if they didn't violate any other terms of probation or conditions of probation placed upon them, then the charge would be dismissed. So they would not have in their future the felony conviction that, quite frankly, would not only be a stigma, but they'd be registered as a sex offender. They would have to go to their, that would be disclosed to the job, any employment, any education opportunities, and really giving them a second chance. At the same time, not letting them go. When I tell you it's either the felony or nothing, nothing doesn't solve the problem either, Mr. Chairman. And so what this bill tries to do is address that in-between area. I would say to this committee that one might look at this and say, well, this gives an out. It doesn't, because there are going to be situations that do not fit the factual scenario that the sexting between high schoolers is trying to address in this bill. Because if you look online, on the last line of the bill in subsection F, the provisions of this section shall not preclude a prosecution under any other statute, which means, as we all know it to mean, that if this doesn't fit, then that doesn't keep them from charging that young person or that person in possession of child pornography under our other child pornography felonious statutes. And that's the bill, Mr. Chair.
Mr. Chair. Okay, so I just want to,
Does everybody have the substitute? Okay. Bill?
so I just want to, as the institutional knowledge person here, just remind everybody why this is so hard. So it is easy to visualize the high school 17-year-old and high school 16-year-old who swap pictures back and forth. No one wants to see them on the registry, convicted of felonies and the rest. It is, usually we say it's easy to catch the guy you want, it's hard to not get the guy you don't want. This is actually the opposite, which is it's easy to visualize the person you're trying to keep out. But we have really, really had trouble doing that without releasing a whole bunch of other bad conduct, creating a roadmap for people that want to do terrible things under the rubric of consent. The reason this is hard is because we don't generally say you have the consent. I mean, the younger you go, the less we care. If a 4-year-old says, yeah, I don't mind that they took a picture of my pee-pee, we don't care. I mean, that's not, and we don't care if it was consensual, voluntary, or anything. We treat it as child pornography, and once it gets into the ecosystem by any means, of course, it's out. It's gone worldwide forever. That is why these have been very difficult. We sent it all the way to the Crown Commission and back without actually reaching a conclusion. One of the things of the Crown Commission was we were not able to find, there were very modest examples where prosecutors weren't properly using their discretion to address these problems. So what I mean is people get charged, the prosecutor makes sure the pictures come back, everything gets destroyed, people do some community service, and it's resolved by some non-conviction method. But that was 4 or 5 years ago. Some time ago we did that in the Crown Commission. Kids are still swapping images back and forth. I mean, same just right off the bat, I mean, some of these very issues are right here, of course, which would be, I mean, if someone distributes a picture other than of him or herself and it goes to a third party, it's gone. You've lost. My girlfriend, I don't use mine anymore.
Yeah,
Well, no, I mean,
it's,
Catherine sends her picture to John. Catherine produced it, she distributed it, John possesses it. Okay, but that's the simplest of all. But the moment John gives it to Eddie, it, as you know, it's gone. I mean, that you can't get that back. John has given it to somebody that's not Catherine. She didn't give her consent from the Senate. It didn't come from Catherine. And now it is in the world. That's my starting point. Is a lot of smarter people than any of us here have tried to come up with something that doesn't. When we went to the Crown Commission, we had something that was a sort of a Romeo and Juliet provision, all consent-based, meaning we protected only John and Catherine. That was as far as it got, and it turns out that made nobody happy. The senator's right. If you simply decriminalize it altogether, you can't even get pictures off the phone. Dad goes to John and says, "Give me my daughter's pictures back," and John can say, "Sorry, Dad. No, she gave them to me." Just identifying the scope and the difficulties presented by the problem. You have really bad people who, if they can get the person to give it to them, I mean, they didn't commit the crime, they didn't produce it, and now they've got a picture of a 12-year-old performing a sex act or something that's sort of within the realm. They can go to their 17-year-old brother and get him to do it. They're protected. In other words, these are the parade of horribles we come up with. Senator, do we have evidence of how often prosecutors are pursuing minors who have this? In other words, where they're treating sexting?
Mr. Chairman, I'd answer the gentleman by saying I don't have exact facts and figures. Maybe the Doug Wilder School of Government might have those, but I don't possess those. But what I can tell you is, at least from my own personal experience, and I think even Delegate Adams can tell you that it's happened in our region, in our area, with at least enough of a frequency that it's becoming an issue and a problem. And
are the prosecutors following through, or are they using it as a way to get rid of the pictures, tell the kids to cut it out, but ultimately not convicting?
Mr. Chairman, and Delegate Bell, I can say I've seen it applied inconsistently in one region. After much prayer and thought, the Commonwealth just felt compelled to charge them all with felonies. And then in
I'm
votes,
just going to get charged. I mean, but then are they following through and getting felony adjudications, or are they at some point pulling the record and saying, "We've got what we need. You've done something. We caught your attention. We got the pictures back."
I've seen deferred dispositions. I've seen other dispositions. I can't say with any certainty what the frequency is that felony is the obvious result. But again, you know, I always go back to line 31 on E, which says basically, look, if it doesn't fit this, then they're not stopped from prosecuting anything else. I mean, ultimately, this doesn't take even that discretion away from them. Mr. Chairman and Delegate Bell, what this tries to do is make sure that they, you know, the one thing that we always want when a minor, remember, it doesn't apply to anybody 18 or older. But what we're really trying to do is correct the behavior, let them see what the behavior is that is objectionable, criminal, and also damaging to society, and correct that behavior. And correct that behavior without ruining their life before it gets started either. When, quite frankly, you know, this is something that we're not even caught up to right now. This gives an ability to have a tool for the Commonwealth to do it. And remember, even in this proposed legislation, it's got to be with the consent of the Commonwealth. So again, Commonwealth doesn't consent, it doesn't happen.
Okay, we're about to try to fix this like we have year after year. So let's start hearing from people. Anybody in the audience wishing to testify in favor of this bill, please come forward.
Chairman, like you said, Executive Director of the Virginia Association of Commonwealth Attorneys, and to sort of echo some of the comments that have been made, there are probably as many different reactions as there are Commonwealth attorneys in the state. When I was Commonwealth Attorney for the City of Lynchburg, probably about 10, 12 years ago, we had deferred dispositions, but we had our own particular program. We had our own particular strategy. And I've heard, just anecdotally from others, that they deal with it in other ways. But the Virginia Association of Commonwealth Attorneys has taken a position in this particular matter to support this bill because of basically, it gives us some uniformity, it gives us some guidance as to how to deal with this particular issue. It gives us that middle ground that we don't have at this particular point, where we've been doing deferred dispositions under the general deferred dispositions for juveniles, and justified as that. But if you have an individual who is under a deferred disposition that does not follow through, it does not satisfy the requirements of that deferred disposition, we have two options. We can convict them of the felony, or we can find them not guilty even though they didn't follow through with the deferred disposition. The other thing that this does is it does allow us in a situation where there has been a deferred disposition. It gives us that middle ground where we're not stuck between doing nothing and giving them a major felony. So, not that I've seen any of the second time around, and in fact, we've in Lynchburg have had no failed deferred dispositions, but it would give us that particular option. And so the Virginia Association of Commonwealth Attorneys does support this bill.
Okay, Delegate Bell.
Really?
Yes.
No, I mean,
Yes, sir.
this would allow distribution and child porn.
And as has been said over and over again, as far as line 31, subsection E, in those particular situations where it is not
Okay, tell me a situation where a sex act involving 5-year-olds
Now,
should be.
five-year-olds, Mr. Chairman, would automatically be inappropriate.
No, it's not, because under this bill, it would be allowed. Why would you be supporting an act
We would-
without Commonwealth, somewhere in the Commonwealth to do that?
We would prosecute that as distribution of child pornography.
Then why is it in this code?
I'm sorry?
Then why are you putting it here, unless you think that's discretion that would be appropriate for someone somewhere to use?
I believe that the discretion is here, that allows us to not go forward with this deferred, this.
I understand, but this would allow somebody somewhere to make the call that they think that's okay.
If they want that be their last term in office, yes.
That's true already. I don't understand why we can't draw, I mean, in other words, you're saying you're not saying the idea is good. We always say the idea is good. The problem are the words. This word says you can transmit child pornography, which is not new, it's not pictures of a new child. I mean, they have to be, pornography. Up until the day you turn 18.
And again, the Virginia Association of Commonwealth Attorneys has taken this particular position. That I can only keep repeating that.
Okay.
Okay. Anybody else in favor of the bill, please come forward. Anybody in opposition, we will now hear your testimony. And now is when it gets weird. Go ahead.
Good afternoon. My name is Camille Cooper with the National Association to Protect Children. We oppose this bill. I want to just step back for a second and tell a little story about I had to bring my daughter to Senate courts one day, and there was, this a couple of years ago, she was about 14 or 15 years old, and it was Jill Vogel had her child marriage bill there. And there was some argument among some of the members about what would be an allowable circumstance for children to marry. And she was horrified. And she leaned over to me and she said, "Mom, they can't let my friends get married. My friends are all idiots. And so just to start off, I want to point out that for adolescents, they go through a very, very, very difficult, tumultuous time during adolescence. They make a lot of mistakes. They don't necessarily intend to make those mistakes. They don't understand the future consequences of those mistakes. I'm not in favor of sexting. I don't condone it. But I certainly don't want any single teenager who sent a nude selfie to their boyfriend or girlfriend to have to check the box when they're 25, when they're asked if they've ever been charged with a crime. So that's the first thing that I'm very concerned about. 2, we're at the 10-year anniversary of Alicia's Law. Most of you on this committee were part of that initiative. The Internet Crimes Against Children Task Forces are your central hub for any kind of child pornography, whether it's teenager sexting or anything else. If it comes in through a report, through the school resource, or whether it comes down through the cyber tip line, however it comes in, it's going to go to your local Internet Crimes Against Children Task Force. Right now, sitting in their investigative database, literally right now, are 10,000 suspects in Virginia trading images of children under the age of 4 being tied up, penetrated, and sadistically sexually assaulted. 10,000 of just those. Those are just peer-to-peer leads on a few of the networks. Our Internet Crimes Against Children Task Force is the most well-funded task force in the entire nation. They're one of the most successful. They're in the top 5 because of the work that you've done to support them, but they're drowning. They're literally drowning in really bad guys, right? So one of the unintended consequences of creating a misdemeanor statute for child pornography, regardless of whether it's 2 teens together or consensual or not consensual, I don't really care, you're going to put in an enormous amount of pressure onto those ICACs. For example, Louisa had a big sexting case that made the news. 174 digital devices were confiscated, and if they had to go through every single one of those devices, it would have literally created a 6-month backlog for that ICAC. In the meantime, all the really bad guys that we're trying to get to languish in that database. So for that reason, I'm very concerned. I don't want to criminalize adolescent behavior, and I also don't want to create a trash can. So on both sides of this debate, whether it's VACA or whether it's Senator Stanley, you're hearing about this idea of prosecutorial discretion. He wants to say it's great, VACA wants to say it's great, but sometimes it's not so great. I mean, I have a lot of respect for prosecutors. I'm married to one, but sometimes they make colossal mistakes, and sometimes they are overzealous, and sometimes they do abuse. You know, prosecutors love something that they can plea something down into. And so to think that this won't be used inadvertently to plea what could be a very predatory adult offender into what is now a misdemeanor offense. You know, that's what legal fiction is about. I'm gonna let my husband sort of elaborate on that. But for those 3 reasons, I would ask you to send this bill off into the sunset, please.
Yes, ma'am.
Mr. Chairman, committee members, Mary DuBois. In a recent news story about this very bill, a Virginia prosecutor stated this bill will allow them to charge more kids. Senator Stanley recently said on the floor about another bill, we're trying to stop the schoolhouse to courthouse pipeline. This bill is at odds with that goal. In 2016, 63 juveniles were arrested in Virginia for pornography. That would be images of juveniles by juveniles. In 2015, there were 96 arrests. In both years, the majority of those arrests were the 13 to 14-year-olds, not the 17-year-olds. This bill will make those numbers go up. Misdemeanors aren't just a blip on the screen. Misdemeanors have costs, not just financially to the family, but emotionally, physically, and societally. These kids, while waiting to hear if there's going to be charges, could commit suicide. This has happened across the country. The shame and the embarrassment becomes too much. This bill may not require them to register as a sex offender in Virginia, but now, especially since it says child pornography in the substitute, if that teenager moves to another state for school, for work, or to marry, That state could require them to register as a sex offender. Higher education, employment, relationships, and even housing becomes difficult and in many cases beyond reach. This bill only applies to juveniles, excluding the 18 and 19-year-olds, who could be in age-appropriate relationships. They may have even received the image as a minor. Studies have shown the brain is not fully developed until your mid-20s. This bill allows 10 images only. How exactly does one more image constitute a step change to a felony? What about a video? Videos record 60 frames per second. Would 1 second of video be considered a felony as well? There is a solution. I've been proposing it for more than 7 years, which is supported by data, but yet no one wants to sponsor it. While I admire this attempt, this cure is worse than the disease. Please vote no on this bill and consider my proposal for next year. Thank you.
Thank you. Yes, ma'am.
Mr. Chairman, members of the committee, Claire Guthrie Gastanaga on behalf of the ACLU of Virginia and our 42,000 members across the Commonwealth. We have consistently over time, at least the last 3 to 4 years, opposed this legislation on the grounds simply that not everything should be a crime. In this case, we're not even sure that the minor who sends the selfie to another minor isn't fully protected by the First Amendment for that expressive activity. And no one's even raised that issue. But this would criminalize teens for engaging in consensual sexting. And it's a situation in which, I don't know if you all know this, but 50% of kids have all of their relationship conducted in either texting or other instant message or Snapchat or those kinds of things. That's how they conduct their relationships. And the estimate is that 40% of all teens have sexted. Now, I'm not sure you want to criminalize an entire generation. And in this circumstance, this bill does not take doesn't assist with uniformity as was suggested. I mean, you don't know whether these kids are going to be charged as adults or juveniles. Somebody's going to make that decision. You don't know, if they're charged as adults, they're going to be in a public trial. They're going to, whatever, this isn't some secret thing that's going to take place and they're going to be adjudicated and deferred and nobody's going to know about it. This is just generally not a great idea. Our view is that the status quo is perfectly acceptable. Commonwealth's attorneys look at cases, decide whether the behavior is certainly egregious enough to really constitute criminal behavior. If it is, then they charge the person with a felony. If it's not, then they figure out ways to work it out with the parents and the schools and their churches and the people in the community. Because, this is so many of our kids who are doing this, and you can't put them all in jail. And so we would respectfully ask you, once again, to let this bill stay in the committee, either by being tabled or passed by indefinitely.
Mr. Chair,
Delegate Mullen.
question. Under what circumstances could somebody be treated as an adult under this code section as it's proposed?
Well, it talks in terms of either being convicted or adjudicated, which at least holds out the possibility that someone would be tried as an adult, because you can't be convicted if you're being tried as a juvenile. You can only be adjudicated delinquent.
I understand, but that could be for a deferral for somebody who was adjudicated under the age of 18 and then the deferral comes afterwards. Under what circumstance could you charge someone as an adult under this code section?
I frankly don't know the answer to that question.
Okay.
I mean, when I looked at this and read the language of the substitute, which is the first time I've seen it, and it speaks specifically in terms of either conviction or adjudication, that holds open the possibility someone could have been convicted as an adult.
But you can't transfer under section B or C.
Right, I understand. You know this much better than I do. I'm not a criminal lawyer. I don't do criminal practice.
I literally do this every day, not
I know you
criminal
do.
practice, just a.
I know.
Thank you.
I appreciate your clarifying that for me.
Thank you.
Anybody else? Okay.
Senator Stanley's asked me to sit down and shut up, but I'll be pretty quick, Mr. Chairman, if you're okay.
But you don't answer to him.
That's what I told him. I said, I'd rather do it with her.
Right.
But I do appreciate with Claire saying that discretion, the status quo of prosecutors is great. I'm the Louisa Commonwealth's attorney. I couldn't be at the backer vote, but I'm completely opposed to this bill. Not because it isn't from my great friend, Senator Bill Stanley, for 4 reasons. One, I will say it's not needed. Two is the resources that it would take. Three, equal protection, and then four, the trash can, is what Camille talked about. Let's talk about why it's not needed. I have been a special prosecutor all over the state, in both state court and federal court, dealing specifically with these cases. And of course, we know almost 4 years ago today is when all of a sudden I'm coming back to the office and I find out over 150, almost 200 students are involved in this, and we got national media calling our jurisdiction. And what was sort of humiliating for me is we had been to the school in the beginning of the year talking about this and how it's a felony, don't do this. And the even worse part, when the Atlantic reporter came out to interview everybody, she talked to the kids, and they remembered the talk, and they knew it. And it didn't stop them. Why? Because the kids have those hormones, they're out of control. So the question is, do we want to bring those 172 kids into the criminal justice system? Well, those that followed the story in Louisa, you know the options we had. First, we could have just sent them to intake, which is where most child pornography cases go when we're dealing with minors as the defendants. So we talk about these terms, felonies and registry. Well, that's really not applicable in 99.9% of the cases, right? They go straight to intake, and our prosecutors don't even know about it because the intake officer reviews the facts. It's a 16 and a 15-year-old. They're a boyfriend and girlfriend. You know what we're going to do? Go do 20 hours of community service, write an essay about why this is wrong, and it disappears. There's no felony, there's no courtroom, there's no lawyers. That's how it happens most of the time. Sometimes you do have somebody that maybe other reasons you feel you need to charge them, which I had to do before. But it's not certifying the case and sending it to circuit court, making a felon, and putting him on the registry. It's because you couldn't get the message to him. Like one we had was a gang member, right? We needed to get the message. It stayed in juvenile and domestic court, right? That's how it was handled. So what I'm telling you, there's a great system that works. I don't know of any case, and maybe I'm wrong, I don't know of any case where a juvenile defendant is actually on our sex offender registry for having been convicted of I call it pure pornography, from a relationship sex thing. I don't know that. Maybe somebody can prove me wrong. I don't know that that's out there. And if we're here to fix a problem, we should identify the problem first. Next, resources. I think Camille hit that thoroughly. Imagine what it's like in a small rural county like Louisa when we have one case like this. Who's going to do the forensic exam? Where do we go? I can tell you, I know all these examiners across the state. Sometimes there's 6 months, sometimes 2-year backlog just to get an examination done. There's limited resources, and there's cases we need to put those finite resources on. And think about the equal protection. The reason I bring that up, if you're a senior in high school, you're 18, you just turned 18 today, and you and your girlfriend or boyfriend just sexted, should you now be a felon, but yesterday it was a misdemeanor? Don't think that argument's not coming, because there are creative defense attorneys that are going to make that argument. That there shouldn't be a one-day difference in high school to determine whether or not you could be charged with a felony or misdemeanor for a peer relationship. So that is an argument that'll come and that'll have to be litigated. And finally, the trash can, and Delegate Mullen, I'm sorry, Mr. Chairman, to the delegate, he mentioned about charging, and I would agree with the delegate's position. One could not be charged as an adult. I think we'd all agree with that. But I don't know why it couldn't be pled down as a legal fiction. For example, in drug court, I was having this conversation with my colleague earlier today, Mr. Berg from Spotsylvania, our neighboring county. A lot of drug courts will take charges unrelated to drugs and plead it down to a legal fiction in order to get you into drug court, right? We do that occasionally. It's not regularly. It's not to say that cases like this might not be pled down where adults, that what Delegate Bell was talking about, when you have that 5-year-old victim, we all know it shouldn't be done, but it could be done. And for those reasons, as my position as the Louisa Commonwealth's attorney, I oppose the bill and ask you to support.
Thanks for keeping it light.
Thank you, sir.
Yes, sir.
Mr. Chair?
Bill.
So all of us are having memories of these debates over the years, and I brought a bill, and I think you brought a bill, and everybody tries hard to come up with something, and we end up in the same spot, and I'm not no further than I was when it was my bill. I was convinced even my own bill wasn't going to work.
This is my first time, so yeah.
You are welcome to the.
And you're right, it did get a little weird back here.
conflagration of.
I don't have it. I've thought hard on this, that it's not just against the usual, it's a flip of the outlaw rule where you can see the guy you're trying to get, you end up getting a lot of other people, and we just can't pass the bill like that does over the years. This is the flip, which would be, I don't see how to protect one person without having a lot of other people being impacted. Road mapping, how bad you guys can do terrible things, so.
We want to fix this one problem so bad, but we don't want to make 10 others, 100 others, 1,000 others.
Chairman, I understand. Believe me, it seems like in some ways what we're doing is like, well, we're not telling it's wrong. I worry about where are you when that father comes in with that daughter and demands of that Commonwealth's attorney, this is what you will do, and you're put in that inexorable position where some people want to say, it's just kids being kids. I'm hearing it from areas where I'm a little surprised I'm hearing it. Well, those circumstances and those things, that prosecutor's in a position where it's an all or nothing proposition, and the consequences could be significant for that person's future in a way. Or they're not taught a lesson. They're not correcting the behavior. They go, as Rusty just talked about, they go right back to it. Hey, we got you taught. Hey, we know you're not going to get us. That's not how we correct young people's behavior, especially in this world and especially with these kids.
Mr. Chair.
That's why my kids have no phones.
Where we have come down in the past, it doesn't mean we're changing lots of things. It's just, as we keep coming back to this, the power of the prosecutor to put someone on advisement for a period of time and try to get it fixed is where it's going to be. And hearing lots of charges, I remember the Lewis case, they were 150, but we didn't have the convictions that people didn't say, oh my God, that's awful because a person should have been registered. I don't know. I'm not, and it's not, I happen to know it's from whoever, that's not the only reason. So I end up not, I'm in the same place I've been, even on my own bill. So I don't want to cut off the debate. The senator's been very generous with his time, but I want to move to BBI at the appropriate time. For there, I'll make the motion.
Okay.
I'll move to BBI. Okay. Thanks.
Is there any discussion? Do you want to say anything else, Senator? We're all frustrated, and we appreciate your taking a stab at it.
Listen, I appreciate what you've been trying to do with this over the years. I've read all the drafts, and I thought maybe we had a component where it was narrow enough and particular enough. It still gave the release valve to make sure that we didn't hamstring our Commonwealth attorneys. But I cannot believe, and I will only say this in closing, Mr. Chairman, I cannot believe that we've got to the point where this is excusable behavior. Kids being kids. It's not. You know, it wasn't when we were growing up, and it shouldn't be now just because they have an electronic device that makes it okay. You know, we had the little Instamatic cameras, but we had to go get them developed at CBS. So that never happened. But here we have instant, you know, everything with this generation is instant gratification. And quite frankly, a lot of what that instant gratification does is create a lack of responsibility and accountability, and changes what we would think is a social norm into, or being against this, into something that's acceptable just because, well, they had an instrument we didn't have when we were growing up, so it must be okay. This is not okay. And there are going to be a lot of parents out there that are going to get mad. And you're going to have a lot of Commonwealth attorneys in positions where it's a wrong proposition. And the kid doesn't learn a lesson if it's nothing. And the kid gets burned up if it's wrong. So, thank you, Mr. Chairman, for your time on this too.
Yes, sir. All right. The motion is to BBI. Please cast your vote. Close the roll. All right. BBI.
Thank you, Mr. Chairman. Thank you.
Is that all you had?
Okay. Luckily, yes, sir.
Okay, all right.
Mr. Chair.
Okay.
Only because I keep on keeping an eye. So next meeting, Wednesday, we think will be our last